Greetings everyone. I Khushbu Chawla from Team Legal Vidya welcome you all to the 27th class of 9-week certificate course on advanced legal drafting by Legal Vidya. Now, I would like to welcome our honorable speaker of this course, Ms. Shivani Gupta, to take the session forward. Welcome, ma'am.
Good evening, Khushbu. Good evening, Legal Vidya, and good evening, participants present in the session. I hope I am audible. Actually, suffering from once again a real sore throat. Weather is changing, that's why. But let's begin the session. So, in the today's session, we're gonna discuss about, as per the schedule, we're gonna discuss about what are the provisions of the application that are being made under the section number 9. There are two drafts need to be shared today as per the schedule. I have already shared one draft with you all in the WhatsApp group. I hope you all have just downloaded the PDF and check out what I have shared. Before jumping into directly into the drafting, we will discuss some of the BRF provisions, some of the concerned law, that what the law saying so about that. Because studying the law just before the starting the drafting is just like you are refreshing your memory, and you are just acquainted with whatever the facts being required. So, as per the today's session, we're gonna discuss about the section number 9 of the Arbitration and Conciliation Act. There are certain provisions for the interim measures, interim reliefs under the section number 9 of the same. Look, since past few days we are discussing about, my voice is clear now, and participants, I will share the screen of the draft after, just after completing, giving a little bit insights the law provision, then only I will share the screen. I hope you understand what I'm trying to say. Okay, if you understand, then gives a thumbs up. And meanwhile, anyone want to ask about the provision or something else, then please put in the chat box. Okay, yes, thank you. Now, as we all just know that, first of all, today's session is about the section number 9 of the Arbitration Act. We are already acquainted with what is arbitration. It's a mode of the ADR, alternative dispute resolution, where the any kind of a commercial disputes, family disputes are being resolved. If there are any kinds of a disputes among the parties, so there are certain tactics being followed, and certain okay, one more thing, when we come to the any kind of a relief seeking from the, either from the court or either from the arbitration, so there are certain reliefs that we need all of sudden. So those reliefs are could be treated as the interim relief. Okay, the proceedings are going on and we need the relief, so there are certain reliefs that need to be, we can say, need to be required or the person seek. When now the thing is just like, okay, the arbitration procedure is also like, that will also give you reliefs, that will also give you all the kind of things that you are seeking for. But the interim relief is just moreover is just like, the proceedings are being going on, and it's like preventive measures or the preventive release that are being granted particularly by the arbitral tribunal. Now, in the case of a civil suits also, there are certain reliefs. You have heard about the interim relief when we were discussing about the civil code provisions. Okay, yes, then also we discussed about those interim relief, same as the reliefs are available here also. Look, the interim relief is granted. Now just keep one thing in your mind: the interim relief is granted. When interim relief will be granted, first of all, we all know that the prima facie there must be a case. Then there must be a balance of, for example, convenience lies with the right party, that the party who is just seeking the relief, or who is just seeking the kind of any kind of relief from the tribunal, arbitration tribunal, arbitrator, and so on. And next is that there must be a irreparable damage or the injury that may be caused if the interim relief not granted. So these are certain general circumstances. Okay, you could also mention that there can be other certain general circumstances or the grounds also the interim relief can be granted. As we all know that under when we will discuss about the civil drafting, then also we have discussed about certain interim reliefs. So that is what the interim reliefs are being granted, and these are the criteria. Now under the under the act of 1996, it's the arbitration and conciliation act. For example, after the amendment of 2015, after the amendment of 2019, and so on, so there is a kind of a safeguarding the interest of one of the party over the other. Now this statement, what I am saying, safeguarding the interest of one party over the other, section number 9 and section number 17, just keep in mind, section number 17 also of this arbitration and conciliation act is just like enabling any of the party to any arbitration agreement to file an application for the interim relief from the court or arbitral tribunal. Okay, so it's a kind of an interim relief that are being granted either by the civil courts or either by the arbitrator or the, if the two or more arbitrators are there, then the constitution of the arbitrator is known as the arbitration tribunal, arbitral tribunal. So you must not be confused with the term that what is arbitral tribunal is. Now we will directly jump into the provision, and that's the basic background of what kind of reliefs are being granted, why there is a need to. Now, a very important thing just to keep in mind is section number 9 of this arbitration and conciliation act mentions that when a party may put up any of the application before the arbitrators or the arbitral tribunal for any kind of a interim relief, and either to the court also, because where we can discuss about the court provisions, civil court provisions also. And there are certain things like interim relief application is put before the court also, and it's just before the arbitration proceedings. Then it must be like during the arbitration proceedings, or you can see at any point before the enforcement of the arbitral award. So there are certain conditions or the criteria being stated in the law itself. But there is one thing, is this, that generally courts doesn't allow a petition for like for interim reliefs, because once the arbiter a tribunal is being constituted, then there it's just like the aggrieved party proves themselves beyond the we can say doubt, that the interim relief has maybe provided by the arbitral tribunal under section number 17. So because arbitration is more about just it's not like the miscarrying the justice, that's why. Now another thing is that we can also say one more thing, nevertheless, the power just or to grant any kind of interim relief to the aggrieved party, and it's just before the arbitral tribunal that is being constituted, and the after the arbitral award being passed, the lies with the court only. Now, the section number 9 also states that if in any of the case the court passes an order for interim relief before the commencement of any kind of a arbitral proceeding, the arbitral proceedings have to be commenced within the 90 days from the date of interim relief. So this is also a time limit. Now, one question will come to your mind, that interim relief that are being sought out under the section number 9, then what are the categories of the interim release might be there? I think anyone would like to answer this, because in the civil proceedings also we have discussed about the provisions of interlocutory applications, interim reliefs, and so on. So anyone present here would like to give the example? Any one or two example would be enough, else I am here just to explain. Please make an attempt to answer. Okay, did you accompanied with the term, acquainted with the term injunction? temporary injunctions and so on. Have you heard? Yes, Anamika. Yes, Sony. Yes, Prachi. Yes. So that injunction is like a synonym for the interim relief. Injunction is just like, okay, we are looking forward just to get the, we can say, stoppage or a kind of a thing for a particular daytime or something. But interim relief is just also like a relief, so the proceedings won't get affected and the aggrieved party sought some of the relief. Now just give me the example for the interim relief. What could be the examples? There can be certain examples, for example, case laws related to the contract, case laws related to the family dispute. Anyone would like to? You can unmute also if there is error in typing, because answering this question only will give you the confidence. Okay, you can think logically, you can think critically, because law is just like interlinked, interconnected with each other. So once you are studying the arbitration act, you have to just keep in mind, okay, whatever the possibilities, because this even in every circumstance you have to evaluate them on the behalf of either arbitration proceedings possible, or either there is a need for the court interference. So prepare any of the circumstance, any of the case law on these two grounds. When you are capable of doing so, then it will be easy for you all. For example, to prevent a person from continuing the illegal construction. Yes, good way. Someone else? Sony, you have given such a kind of a domestic example, but really appreciable. At least you make a attempt. Yes. Anyone else? Bhavna Gupta, Shrishti, Prachi, Rahul, and Anamika, Anmol, Madhukar, Ankita, Chelsea. These are showing on my screen. Kirtan and Vijay. Those whose names are not displaying, they will be like, okay, thank God, ma'am didn't take our name. Either gives a thumbs up on this thing only, because it's not a monologue session. No one is just ready here to. Okay, no worries. I'm just telling you. Yes, so interim reliefs under the section number 9 uh, can be, which are being just sought by any of the party. So it can be just appointment of the guardian for the unsound mind person, whoever agrees so. Either note down somewhere. Appointment of guardian for the unsound person, appointment of the guardian for the minor person. Next, you can say it's about the securing amount of claims, or next is detention procedure allowance, or it's just like preservation or inspection of any of the property or the thing. Next is preservation, interim custody, or sales of goods for any goods related to the arbitration agreement. So these are some of the aspects where the interim reliefs are being granted. Now, what happened moving further? The another thing we can also mention, it's just like a of the receiver also. Now, the thing is, any of the party of the arbitration agreement, they are just like filing the application to the whatever the concerned court is there, and the application being filed under section number 9. Now, before or during the course of the arbitration, then what would happen? And after there are two things. First thing is this: after the pronouncement of arbitral award, only the successful party who is just entitled to seek enforcement of the arbitral award may just file an interim relief. Now, another aspect is this, that the unsuccessful parties of the arbitral proceedings would not be entitled to file any kind of an interim relief. why there is such provision? I think you must be confused and you must be shocked to listen this, but this provision is for the reason because there is no as such reward that is to be that is like we can say to be enforced in its favor. So it's just about if the pronouncement of the arbitral award for the successful party is just the party who can file the application for the interim relief. Now, if there is a case like the arbitral award being set aside, or the unsuccessful party means whose claims are being rejected by the award, then they cannot even apply. It's just the section number 9 saying so. There is a jurisdiction also for the same. Jurisdiction is just like the court of the seat of arbitration have the jurisdiction in the same. Next is the one thing also you have to keep in mind regarding the section number 9, that is the enforceability and the appeal against section number 5. So yes, the any kind of, first of all, just clear one thing, that is the any kind of a relief that are being granted by any of the court has to be enforced by like any other order of the court. It's as simple as that. Now, any willful non-compliance or any kind of a disobedience is there of the interim relief award, then that could be treated as a contempt of court. And you already know that contempt of court is a criminal offense also, and that is also dealing with the according to the laws, whatever the laws are there. But the appeal in the case of an interim order can be made to the suitable court, and that is as per the section number 17. I think it's subsection number 1 only. Just please you check it by yourself, it's your homework. It's section number 37, subsection number 1 only. Now the okay, section number 17 is enough for you all. So yes, till now I think you don't have any doubt about the law. Now I will share the PDF of the draft with you all. Just wait for a second, be in the class. Meanwhile, just gives a thumbs up or write something if the concept is clear to you all. If you have any of the doubt regarding the concept, then please let me know. Just wait a second, I'm sharing the screen of the draft. The video is lagging here, don't know why. Does the screen is visible to you all? Okay, Sony. Okay, Anamika. Yes, so it is a draft for the application for the interim relief. Now the application for the injunction is also being stated as same. Now just look into the draft. I have mentioned that it's a P and it's a D. P for the plaintiff here and D for the defense here. So no need to get confused about why I have mentioned P and D. Okay, plaintiff versus the defendant. Now we will mention application for the interim relief. Now we will start it with it's just a draft, and you can make the certain changes that are being required, so on as per the circumstance of the case. Now it's a family dispute draft. We will discuss each and every point. The plaintiff above name submit the application, and it just bring to state. First of all, we will mention about what are the facts or of the case and so on. That plaintiff has filed the suit for partition. It's a suit of a partition. Okay, can you please anyone tell me where is the partition we discussed about under the family laws? I think Hindu law and the Muslim law everyone have studied about. Partition under which law? Please don't Google it. It's a general question I am asking. It's not a monologue session. It's a two-way session. Succession Act, Prachi Gupta. Okay, good going. What's the full name of the Succession Act? Either it's a Indian Succession Act or something else. It's a family dispute case. Okay, directly jumping into the draft. The plaintiff has filed the present suit. Now, the case of the plaintiff is just suit related to the property being ancestral, and that is being held by defendant, and defendant who is also the karta of the family, and the family against the karta. And the karta of the family, where the plaintiff is also the member of the family and the defendants. Now, what happened next? The plaintiff submits that he demanded partition on that particular date, but defendant they are refused, and high-handedly a manner abused the plaintiff, threatened him, and so on. Whatever the things happened that we will mention in the point number 3, point number 4, and so on. Now, the next is this, that the plaintiff has also submitted if the considerable time finally taken. Now, in the next fifth number point, the plaintiff is sanguine about the success of his suit. Next, we have mentioned the plaintiff therefore prays that during the pendency of the suit, add interim injunction. Now, the term comes the injunction. You would be like, we are discussing about the Hindu Succession Act 1956. The Hindu Succession Act. Okay, Anamika. Okay, sorry. Good going. Yes. And now we have mentioned a one term. The one term is related to. Wait for a second. Am I audible? Actually left by the meeting.
Yes, ma'am, you're audible.
Okay. Actually, it's a Wi-Fi connection. That just got lost. Wait, I'm just sharing the screen once again. Just wait for a second. Please confirm the screen is available. Actually, it's not displaying on my end because I'm just using the mobile internet this time. Okay. If the screen is not visible, then please let me know. Okay. Now the thing is, yes, we were discussing about one thing, that the injunction is the thing that is being mentioned. So injunction is what, unlike a kind of a temporary reliefs you are seeking from the court. You want to just get a stable something, so that there are certain possibilities, affirmations for the plaintiff and part and the aggrieved party and so on. So that's why when we discuss about the interim relief, so we can also mention it just like a injunction application. Temporary injunctions we have all discussed about the same under the CPC. Now it's just like under the point number 6, that the plaintiff therefore prays that during the pendency of the suit, the and add interim injunction restraining what the injunction they want to get granted is just the defendant from obstructing the plaintiff in his enjoyment of the suit property be kindly issued, that the defendant should not be just like, okay, asking to leave the property or not to reside them there. and the affidavit is also being filed, and it's just like forwarded with the help of that plaintiff signature. I think yes, signature is there, date place is there, and for the advocate. And as we all know one thing, that under the civil proceedings, when it's come to the civil proceedings, then what happened, we have to just take oath for whatever we are stating, we are submitting in the court. So we are taking the oath not by just standing in the court and we are taking the oath, we have to submit in written. So for that we are submitting the affidavit declaring that what we have mentioned in the application, so to written statement or any kind of a submission is true to the knowledge and belief. Now it's just like a affidavit. Affidavit is there that the I, whoever the plaintiff is, states on solemnly affirmations, and whatever the affirmations are, those are the facts of the cases. That whatever the facts that property is just this described in the para number 2 of the plaint, originally belonging to this place, and this suit come to devolve upon the family of the plaintiff and the defendant, and it's been managing the property as the karta of the joint family, and so on. Under the point number 2, point number 3, point number 4, and point number 5, we have mentioned about what are the circumstances are there. Now, under the point number 6, yes, the important thing is that the plaintiff and defendant are governed by the Mitaksha School of Hindu Law. Anyone would able to tell me what are the other schools of the Hindu law? It's Mitaksha and Dayabhaga School. Very good, Soni. So, is there any difference between both? Dayabhaga, yes. I think every law student in their first semester studied about Mitaksha and Dayabhaga. Okay, and what are the schools under the Muslim law? Anyone, please? Are Shia Sunni the schools? No. They are not the schools. Maliki is there. Wahabi, Hanafi, Salafi. Yes, Maliki. Good, good. Yes, yes, yes. Hanafi is there. Maliki is there. Wahabi is there. Salafi is there. Good, good, good. Okay, okay. Shia Sunni are not the schools. Okay, so yes, that thus we are governed by the Mitaksha school, and the plaintiff is just entitled in the ancestral properties regarding that, and then we will mention the affidavit, will give the oath upon the same, and then it will be just like made by plaintiff, and the signature will be put on. So this is particularly the draft for the today's session. Another draft is also there. Then that draft is that the draft is related to the defense. So defense draft, have you we have already discussed about the written statement. Have you revised the written statement? Yes, I have given an exercise also on the written statement. So written statement is only the defense. Here they mentioned two things: the defense and defense application also. So there is no such provisions with the defense application. It's the written statement only, and I think there is no such relevancy to share it again. The defense that written statement. So today I will try to give you one task so that you can practice upon the same for the interim release. Uh, okay, how many of you are acquainted with the Domestic Violence Act? DV Act 2005. I think most of the law students are acquainted with. Okay. So yes, so today I will give you an activity. I will put in the WhatsApp also, on the WhatsApp also. The activity is you have to prepare an application for the interim relief under the Domestic Violence Act 2005 regarding the relief of paying a particular amount to the wife till time the proceedings are being there in the court. So that is the draft you have to prepare for the interim relief that the proceedings are being going on. So the husband have to pay a particular amount of 10,000 rupees to the wife so that she can bear her daily expenses and so on. You have to draft the application. Would you be in the capacity to draft the same? If any of the doubt arises, then please let me know. Okay, Anamika. Yes, anyone else, please? And nothing to worry that what you have to mention in the draft and so on. You have to just simply mention, okay, these were the dates of the marriage, place of the marriage, any children is there, you can mention. It's a hypothetical situation. Then what you have to mention, that they are living in a matrimonial obligation. Somehow the things were get worsened. The wife moved to the for their parents house, and now domestic violence application suit is being pending in the court. Sorry, application case is being pending in the court. Meanwhile, for to bear the daily expenses, it's a request to for paying the husband the 10,000 or 12,000 rupees per month to bear the daily expenses of the wife and the child. So, and whatever the court may deem fit, think so. So this is the thing you have to mention in the application, and you have to write an affidavit. I think no one have any problem regarding the drafting of this interim relief application. Yes, anyone have? Okay, Prachi. Students are just like, including me, 17 people are here and only 2 people have given me the reaction. No problem at all. Students are even not spontaneous. Okay, Madhukar. Yes, the students are not spontaneous. Okay, Akash. Okay, okay. Yes, anyone else have any question? Yes, yes. Okay, okay. Thank you. Got you. Anyone else want to ask something? Want to clear their doubts regarding anything? And till now, we have taken, I think, 26 to 27 classes. So if you have any question, any doubt regarding any of the thing like this, please feel free to ask me. Else, we are done with the today's draft. Tomorrow, we will meet with the new draft. Anyone want to ask anything about any of the law? No one is asked, have any doubt. You people are going to colleges daily. You people are doing the moot courts now, because I think it's a high time to do the moot courts. Else in the December it will be exam, then the winter vacations. No one have any question. Everything is clear to you all. You are all acquainted with what the law I have taught, what the drafts I am sharing, and most important thing, how to determine what are the facts are relevant to add in the plaint or the memorial. Look, Sony, plaint is an another thing, memorial is another thing. Plaint you file in a court, and memorial you file in a moot court. So both are, and memorial are based on the behalf of a hypothetical case. Okay, they are just the artificially made facts on the basis of a hypothesis, assumptions, and so on. And most importantly, what are the facts relevant? Means what are the facts that all the facts those are relevant that are helping you in making the court first of all acquainted with what's the mishap with you, and they are just in helpful in seeking relief for you. So those are the facts, and there is no such criteria to determine. It's just about just think the problem, read the problems. If you are drafting a memorial, read the problem either 5 times. You have to read it. 3 times a rough reading, then 4 times starting with thinking like a plaintiff, and then next in the fifth reading, start thinking like a defendant. And you will able to come to know that okay, these are the things being required to be mentioned in the memorial or in the plaint. Sony, I hope your doubt is clear. Yes. But plaint and memorial both are different things. Does anyone else want to ask anything? Tender Moot competition is out today only if you wish to. Little worried about clarity and completion of the syllabus. It's really vast. Actually, Anamika, there is a one strategy now that out of the 10 topics, prepare either 7 to 8 topics and just revise them accordingly. Actually, preparation is not tough. It's just a revision, and to keeping the facts in mind is tough. Just mark the MCQs as much as possible, and just go through the judgments. And just go through the live law videos. Judgments pieces are very important, just to go through. Just you have to make and it competition is not only about the knowledge. They know that you know everything. If you are in a law, you are attempting this. It's about the accuracy also. So please try to sharpen your skills along with the completion of the syllabus, because somehow the paper is of average type, but paper is too lengthy that you are unable to cover. So if you are unable to cover, then it's become a tough paper. So please try to sharpen your skills also regarding the reading, regarding marking the MCQs, means about the accuracy. Anamika. Yes, anyone else want to? Yes, Anamika, anytime. No, no, thank you at all. It's my duty just to clear all the doubts. Being a law faculty, all just I can do is just clearing all your doubts, and it's very important. Please mark as much as MCQs as much as possible. Try to solve previous year question papers 2 to 3 times. Don't be just like, okay, I have done with the question paper, why to solve them again? No, 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 you are wrong. You have to just improve your accuracy. So start marking along with the time, 2 to 3 times, and the practice is the only thing making the man perfect. So that you have to keep in mind. Yes, anyone else? Yes, Anamika. I think we are done with the today's doubt and the questions. I hope you just people do your best in the law. Just please, it's a very urgent requirement of the new generation to be in law. Just study hard, study, read as much as possible. Just do one thing, read as much as possible. Whatever you like to read, where textbooks. And start with the jurisprudence. It's very important. Okay. I think we should wrap the session because that's all for the today's drafts and so on. We'll meet you tomorrow with a new draft. Take care, stay safe, stay healthy. Winters are about to be reached on your doorstep, so please start wearing woolens. Take care. Thank you so much for attending the session. Okay. I think Legal Vidya is not there. If they are there.
Yes, ma'am. So shall we wrap up?
Yeah, yeah.
Okay. So thank you so much, ma'am, for making this session so knowledgeable and engrossing at the same time. Also, I would like to thank everyone for joining the session. Thank you so much.
Good night. Thank you, Kushbu.
Good night, ma'am.